Legally Speaking with me, Tarun Nangia. Today, we commence the part 4 of our series titled Chief Justice of India, Justice Suryakant, Opportunities and Suggestions. And this is our flagship series where we aim to sort of highlight certain opportunities that a Chief Justice has and also certain suggestions that the eminent panelists do share based on their experience in the court of law. Many prove very useful. And we have sort of a panel today that is, in a sense, eminently qualified to share these inputs. I have somebody who I call very jovial by nature, Justice Ajay Rastogi. He's a regular feature on the show. Good to see you, Justice Rastogi. Thank you for your time. Uh, I have with me Senior Advocate Sanjay Jain, who served for 10 long years as the Additional Solicitor General for India between 2014 and 2024. Now he's back as a defense counsel in the Supreme Court. So good to see you. I have with me two people who are very have a following at the bar. They very much liked Senior Advocate Priya Hingorani and Senior Advocate Nandita Rao, and both have a huge fan following at the bar, if I may say so, and both have gladly obliged at a short notice. And in fact, Ma'am Rao is outstation arguing a matter, and she's made time. I thank you, and also she joins Legally
Thank
Speaking
you.
for the first time. So, but hopefully not the last time. All others have been. So she joins us. So welcome to Legally Speaking with Tarun Nangia. At the outset,
Thank you.
I'll request Justice Ajay Rastogi. So, among this panel, you are the only one who's served in the Supreme Court as a judge, and you are the only one who's seen this from both sides. So, the opening comment, over to you for it.
Thank you, Tarun. Tarun, I first must congratulate you that you are also playing a very key role in the dispensation of justice. And your keenness always remain upright that how the things can be made more smoother, more faster, and dispensation of justice will also move around with the people are expecting sitting at the corner of the country for justice. And you asked me, I think Justice Suryakant has a long term of working as a lawyer, as a judge, and he has a pulse of the ground realities. And I have seen him working as a lawyer, as a judge, and now as a Supreme Court Chief Justice also. He has a pulse of the whole system. But he just wants a course correction that whatever the further decisions he may take in implementation must be in the better course. And dispensation of justice may start more smoother and faster. Tarun, my only request is twofold. Pendency of cases in these courts is a very long phenomenon going on. And I share, when I joined bar in 82, there was a pendency. 2004, I became a judge, there was a pendency. 2023, I left the Supreme Court, the pendency is there. Now, I don't know whether I default myself in saying that I am the one who created the pendency when I was a lawyer, or as a judge, or as a Supreme Court. So that is one part. But it is really, as on today, it's very alarming. When I am looking forward to the data, more than 5 crore cases are pending in the courts here in our country here, in judicial courts. And approximately 4.6 crore cases are in the district courts. My only request is one. When we attended seminar or some symposium somewhere, the highlighter is only at the High Court and the Supreme Court. My request is we should now confine to first at the district court's pendency, because the grassroots level man approaches the district court, not the High Court or the Supreme Court. So there should be a focus on the pendency with a 10 years roadmap, that what strategy should be prepared and how it is to be implemented in the district courts to take care of and cater with the long pendency of cases. Because somebody has said, if we now block and say there should be no further institution, the pending cases in courts will take 324 years to resolve. So God knows when the backlog and areas will be cleared from these courts. So my suggestion is one, first, there should be a court committee to be constituted. at the level of the Supreme Court to prepare a roadmap for 10 years, minimum 10 years. So at least 10 years, one decision must follow downwards from the Supreme Court to the District Court. And if you ask my suggestion would be, apart from the collegium judges, there should be all successive chief justices who are also on the bench must be a part of that particular committee. Bar council members, bar association members, and 2 members to be nominated by the chief justice in its prerogative. And that committee must function as a core committee. And committee business would only be for finding out how the areas of cases can be taken care of. That is the first which is possible to be done. So constitutional committee at the Supreme Court level, and at every High Court level, there should be a committee, because in every state there are some similarity and some peculiarity of working. You can't have a one SOP which follow all the district courts in all the 25 high courts where the courts are working. So in every state there should be one committee, particularly for the purpose of areas, and those judges who have a tenure, they should be a members. Seniority should be waived out. My problem is in our system. I'm sorry, I will also blame myself. Seniority has a very role to play. Everywhere we want senior judges to come. My request is not. Those who are willing to come, those who have a long tenure, they must come, join hands, make our roadmap for the future. Not seniority. If seniority background is not taken away, the system will not come forward. So at every High Court level, there should be a committee. 2 senior judges who have a long tenure, 2 judges from those who are coming from the district court as High Court judges. They know how the district court functions, and take few lawyers from the Bar Council and the Bar Association. They must prepare their report and make it available to the Supreme Court committee, which I just requested, and let that committee examine as to what are the bottlenecks in the district court functioning and what is the SOP would be standardized for different states. That could be a formula for which a committee can function for the areas of cases. That is my first and
Opening comment.
Only one thing I'll tell you one thing. Government is a litigant in 50% of the total pendency. Sanjay Ji is here. He has appeared for the government for a long time. Government has to find out some solution across the board, sitting with the judges, sitting with the departments, how the things can be minimized. And these decisions, I don't agree that in matters of income tax where the demand is 2 crore, spend out 3 crore, do this, 4 crore, this is not the system. This weeding out system in a shedder is not the justification. If it is public money, every penny of the public money must be saved, rather than you dispose of in this fashion by putting all these matters in shedder. So these are the things which my first comment for the areas of cases are concerned.
Thank you. And because you mentioned senior advocate Sanjay Jain, I was lunching with a managing partner of a law firm who I think had the opportunity to work with Mr. Jain, and he said he bats equally well on both sides. And he has his own persuasive way with things. He's, I think, never the loud one, but he gets his way through his chat. Mr. Sanjay Jain, senior advocate, over to you for your opening comment.
See, one very important aspect which Justice Rastogi mentioned is about the participation of lawyers in the decision making. Lawyers are the stakeholders in the justice delivery system, but as it so transpires that in every decision which impacts the justice delivery system, 99% times the participation or the decision making is confined at the level of judiciary only, and very rarely the lawyers get a chance to hear their voice. So this is something, this disbalance should be taken care of. And I believe that in the regime of Chief Justice Suryakant, this aspect would be especially taken care of, given the fact that his lordship started his career from district courts, and he understands the pulse of the profession at the very grassroots level. So this is a very important aspect which Justice Rastogi mentioned, and I would like to completely endorse that aspect. Two statements which were given by Chief Justice Suryakant just before he took over as the 53rd Chief Justice of India. One was reinforcing predictability in judicial approach from the perspective of a common litigant and non-elite litigant. And second aspect was that when he mentioned that he would like to dispel this belief that Supreme Court is a place only for the elite litigants. So taking a cue from that, I would like to approach my opening comments with some suggestions which I see are very important from the perspective of the bar and the lawyers, who are, as I said, are uh, equal stakeholders in the whole system, if not greater. Uh, and since they represent the collective wisdom of clients, so in fact, they are, I would say, in terms of percentage, they are greater stakeholders than the judiciary. That's my view. Because if you take three pillars of the judicial or the justice dispensation system, the clients, the persons who articulate the point of view of clients, and the judges who decide. So that way, some amount of majority stake has to be given to clients and the lawyers collectively. This is my belief, and this is something which, uh, if at the highest level this aspect is appreciated, then it will only lead to a healthy, more healthier situation. So from our perspective, if I divide my opening comments into three parts: one, what is needed in Supreme Court? What is needed in Supreme Court is a better ecosystem for lawyers. For instance, when the lawyers clear the defects in their filing, after that, there is no time limit for the registry to do the verification. The registry takes its own time to verify. So there should be some time limit imposed on the registry to verify the defect cured petitions. Because right now, this is leading to a great deal of uncertainty, because the AOR has to also tie up with the lawyers who have to argue, and the clients from far off places, they travel to Delhi, they go back, and this is very expensive for them. Second suggestion that I would make, especially from Supreme Court's point of view, is this: that in the matter of personal liberty, that is bail, just like it happens in most of the high courts, there should be a system of advance notice to the state, so that the dates on which the matter is listed, no date is getting wasted only for the service of the state, particularly when all the states are represented in Supreme Court through their standing councils. And the other aspect, which is equally important, is FIR mapping. What we have seen, and it has something to do with reinforcing the predictability. A matter arising out of same FIR, different matters which are listed in different benches, they arise out of same FIR. So in a one particular bench, a particular person succeeds in getting a bail order, and in another one he doesn't get, somebody else doesn't get the bail. So this leads to some kind of an anomaly, and this is not desirable in terms of consistency and the predictability. So this also impacts the overall impression of a common man vis-a-vis the justice delivery system. So if something to this effect can be done by his under his lordship's tenure as a chief justice, that there is a FIR mapping, that in the sense that all matters arising out of same FIR are listed before the same bench. So this is one aspect. And another aspect is, of course, that again from Supreme Court practice point of view, that because if this has to be done, if you have to do FIR mapping and different matters have to go um, in an equitable manner, then maybe there is a need for restructuring of roster also, so that the 17 possible benches in Supreme Court, they are able to get all kind of matters listed, and the litigant is in a better position to proceed further. So this is my opening comment, and about other aspects which I would expect in his lordship's tenure. If you give me an opportunity in the second round, I will speak.
Thank you. Thank you. I'll go to Senior Advocate Priya Hingorani for her opening comment.
Yes, Tarun. So I would start by saying I agree with Justice Rastogi and Sanjay to some of the aspects which they have mentioned. The suggestions that they have given are also something which I feel very strongly about. But apart from that, I, having been in the Supreme Court primarily for the last 3 decades, I can, and being as an office bearer also of the Supreme Court Bar Station, and as a lawyer in Supreme Court, I can say that, we have seen a lot as lawyers and seen the way the courts have progressed over the years. The one thing which I feel, and I echo the voice of many lawyers of the Supreme Court, is that there is no uniformity in the judgments which come from the different courts of the Supreme Court. And that is something which Justice Suryakant, in his speech at the Constitution Day speech, also reflected upon, and said that there is something needs to be done, some kind of a via media needs to be brought out where all the courts maintain some kind of a uniformity. And I think that's very important for the litigants as well and for the justice delivery system. The second aspect, which I strongly believe, and of course has been said by many chief justices in the past, judges also in the past, that representation of women is very dismissal. Very few women at the level at the Supreme Court, as judges of the Supreme Court, as judges of the High Courts. Representation of women really needs to be worked on and looked at. And we have some fantastic women lawyers, fantastic judges across the country, and we really need to have many more. The third aspect, which I really feel, which Justice Suryakant is very passionate about, is mediation, which I also am very passionate about. And in fact, in the Constitution Day speech, President Murmu also referred to that and said that why cannot we take justice to the doorstep of people, which is something I personally feel mediation is one via media. ADR, alternative dispute resolution, is one via media, where we can take justice to the doorstep, particularly in some class of cases, if not all. And I think now the legal fraternity, the judiciary, the common man is understanding the concept of mediation. It's just a question of channelizing it, institutionalizing it, and taking it forward the way there is a vision which the Honorable Chief Justice, Justice Suryakant, has laid out when they started that mediation for the country, which was started in July.
Mediation for Nation, yes.
Mediation for Nation. Yes. And the second phase is starting just very soon. The second phase for that is also starting, I think, early next year. The other comment which Honorable Justice Suryakant just made today during mentioning of a matter, when people were members of the bar were mentioning, was that from 1st December there are going to be some changes on the working of the registry, on working of on how mentioning would go about. So we are expecting from the 1st of December, which you mentioned in court, was that you will see some reforms, some changes that they are planning to bring out, and he's just been here for a week now, and he is hopeful, and that's what he said, that let's see how it works. I'm hopeful it will work. It will ease out the pressure on the lawyers and on the litigants. So we are looking forward to that on 1st December.
Thank you, Senior Advocate Priya Hingorani. Now I invite Senior Advocate Nandita Rao to give her opening comment on Justice Suryakant. Over to you, ma'am.
Thank you, Tarun. First of all, I very much congratulate Honorable Justice Suryakant on his taking over as Chief Justice of India. And like all women lawyers, I mean, I'm so happy that a feminist judge is at the helm of affairs, because by ensuring reservation in bar associations and hopefully in the bar council, he has given women lawyers who are smaller in number but also important stakeholders in the justice system an opportunity to have a voice, and we are very grateful for that. Secondly, I join all the other speakers in saying that Justice Suryakant has a great commitment to mediation and let me call it restorative justice, because in the litigation process there's only one winner and sometimes there are two losers, because the whole process is so toxic. So his focus on mediation reflects his temperament, which is a temperament of restoration, that the dispute should be ended in a way that is healing and where the litigant also has a voice. So I think this is also a feminist thought process, and I'm sure he will promote mediation and strengthen its feet. And legal aid, I think that for all these things to really be powerful, access to justice is most important. So I personally feel that Legal Services Authority has to go to the homes of people, to bastis, to areas, rather than waiting for people who need legal aid to come to the courts. There have to be a lot more outreach programs so people know their rights, so people know, and I do hope that Justice Suryakant is going to focus on this. Two short points also I want to make, because Tarun, I'm so sorry. It's so nice of you to give me this opportunity to be on Legally Speaking, which is a show I enjoy a lot. And whenever I see it, I watch it. But because, as you know, I'm outstation, so I have to rush off. I may not be able to continue in the discussion. Just two quick points. I do hope that Honorable Justice Suryakant impresses upon the government that it is high time that the strength of the high courts increases, because one of the main problems is our judges are working extremely hard, the bar is working extremely hard, but because the number of litigants has increased so much, which I think is a positive thing, because people are accessing justice, but their matters need to reach. Every court needs to have only 20-25 matters in a day. So for that, we need a constitutional amendment, and I think there is no other solution to disposal than increasing the number of high court judges, or bringing in the retired judges who are willing to serve and who are willing to dispose of matters. And lastly, I think one thing is AI has its positives, but it has a lot of dangers too, because a lot of fake videos, fake photographs, fake judgments are floating around the place. So I hope the Supreme Court research wing comes up with some technology that the registry can filter out these fake things and flag them before they become a bigger nuisance and a bigger threat to lawyers and litigants. So this is what I would like to say and suggest.
So thank you, Nandita. And there was gossip going on at the bar last month that there is a high possibility that fake citations are given and
Yes,
are
these fake.
delivered. So
Yeah, these
fake
fake
citations.
citations. Recently on LinkedIn, I saw somebody had shared that, you can get a prenuptial agreement, and he had given an opinion which had a lot of someone else commented. I didn't verify that. Look, these citations, and I'm unable to find. So this, in an overloaded system, it will add another layer of overloading to judges. So we lawyers also, I've become very cautious. If someone gives me an open source citation, I always verify it in SCC before citing it. So I hope the court, IT division does something to weed this out, because it's something that's frightening.
Since you're traveling and you have to
Yes.
leave, I'll have to
Thank
take
you.
this question to you first,
Yes.
Nandita. Any good wishes for Justice Suryakant's tenure in 30 seconds? Since you have given him some suggestions, I think good wishes are in
Yes.
order.
So I wish Honorable Justice Suryakant all the strength of the great Constitution of India, all the support of the bar, and all the blessings of the Almighty. That he's an inspiration for first generation lawyers, people from middle class families, rural backgrounds, and we wish him all the success. We are all with him.
Thank you. Thank you so much for
Thank
tuning in. I
you.
know you were traveling,
Thank
but
you.
great time.
Thank you
Appreciate
so
you
much.
joining us.
Yes, thank you. Thank you to all my senior co-speakers, and I'm so sorry for leaving in the middle. Thank you.
Thank you. So now this was Senior Advocate Nandita Rao. Now we will go to Senior Advocate Priya Hingorani, where we will take the final suggestion and good wishes for Justice Suryakant, because there is a list of demands and suggestions, and we have short on time. So your final suggestion and your good wishes for Justice Suryakant.
I don't. I think he's been bombarded by Justice Suryakant has been bombarded by suggestions and observations, and I think the kind of person he is, the humble, quiet, firm person that Justice Suryakant is, and the kind of wisdom he carries with him over years of being as a judicial officer since 2004. I don't know whether it's in my place to give any suggestions to him, but yes, I would just definitely say that we are there to support him at whatever step he takes. We are there at the Supreme Court bar, in other bar associations, and I'm sure there to stand with him and take forward his suggestions and recommendations. We look forward to a very, very vibrant 13 months in the next 13 months. And I also feel that, it's not easy for him. It's a very difficult phase that our Indian judiciary is going through, with a lot of backlog, with a lot of pulls and pushes, with a lot of requests from the bar. The bar has grown tenfold, and we have space crunch, infrastructure crunch, financial crunches. So there is a lot of expectation from the Honorable Chief Justice, Justice Suryakant. But I'm sure he already has a blueprint and he has a roadmap in his mind, and he has thought what is he going to do in the next 13 months. So we wish him all the very best for that, and wish him good health, because I think that's very important. And I'm sure Justice Rastogi would agree, sitting on the chair the whole day, it takes a toll on your back and on your physique and on your health. So wishing him very good health and a very great tenure, and we're all there to support him.
Thank you. And Senior Advocate Priya Hingorani, you saying it matters a lot, because I sincerely believe when someone like you says it, it's the message from the bar, because the kind of following you command. I'll go to Senior Advocate Sanjay Jain for his final suggestion and his good wishes.
See, Justice Suryakant possesses a kind of a trinity. He is a man of masses, he is a man of action, and he is a man of intellect. So surely he would be in a position to introduce certain reforms, which will be long-term reforms in the roadmap for the Supreme Court. And in that regard, given the fact that His Lordship has great experience in legal aid side, especially in Nalsar, etc. So on that, I would just articulate the point of view of the counsels and the litigants who come from far off places. So we often speak about the VC being a mode of submission in the Supreme Court. But what happens, Tarun, is this, that when VC is resorted to in a hybrid mode, in the sense that one counsel is physically present in the court and other counsel is on the VC, then it creates a kind of a chaos. So to facilitate this option in a greater convenient manner for the lawyers who are from far off places representing clients with moderate means, that a particular time is fixed in those matters where a request comes from far off places lawyers that they want to address on VC, so that even the lawyer at Delhi can be requested to join on VC, so that that hybrid situation can be avoided and a proper hearing can be given effect to. So that is my suggestion with regard to making VC a more meaningful medium of submission, because hybrid system creates a chaos. That is one. Secondly, I would simply say that His Lordship, being part of that President's reference bench, where the governor's issue has been answered, that they have used a very beautiful expression that is Swadeshi, a tool of interpretation. So I would expect that in Justice Suryakant's time, this over dependence on the doctrines which have been foreign doctrines and have been sought to be applied in Indian context, undermining the fact that India has its own great history and tradition and heritage. The Swadeshi tools of interpretation would be something I would be looking forward in the 14 months of Chief Justice Suryakant taking a great flight and catching the imagination of more and more honorable judges of the Supreme Court. And just closing it with Justice Rastogi, Priya mentioned about the health issues. So that is why Justice Rastogi immediately after demitting his office has taken to golf big time. So that underscores the point that health is very important for the honorable judges to maintain. Thank you so much.
Point well. So as I always say, judges have the last word. So we will go to Justice Ajay Rastogi, who now, of course, is a leading arbitrator. Over to you for the last word.
Before
Priya, you said something?
I was saying just before Justice Rastogi responds, Sanjay, you must know Justice Rastogi is a fantastic badminton player, and had the occasion of playing together, and he still plays, and he's fitter than many of us.
Okay, glad to know that. Over to you, Justice. I have seen him on the golf course, but badminton court is one place I don't go.
Me and Priya we are the partners in doubles.
Yes, okay. And we did a very, very strong team.
Glad to know that. Over to you, Justice Rastogi, for your closing comment and your good wishes for Justice Suryakant.
I'll just make very short comments now on the subject first. You see, reforms are always welcome. Every Chief Justice who comes in office, he always tried his best to make reforms with no personal reservations. But what we find is the ground reality does not meet with the changes which are coming forward by the successive Chief Justices from time to time. So what I suggest is there should be a roadmap which must follow for the coming 10 years in laying down the reforms in the system. It can't be overnight, you can't reform. So there should be a 10 years roadmap, and every coming successive Chief Justice must be a part of that committee, so that that roadmap must be followed for the coming 10 years. And no changes will be made. Then only the reforms effectively will work on the ground. Otherwise, all these reforms remain on papers, ground realities will meet it. That is my first request. My second request is, that is in reference to areas. Because you can't take all decisions overnight. It will take time to understand the situation. Where are the bottlenecks? Where are the matters they are stuck? Like I'll say 138 Negotiable Instrument Act, in my view, has to be reviewed by the government. This has clogged most of the courts in the district courts. In every state, you will find almost 2.3 lakhs, 3.4 lakhs, 4 lakhs matters pending in 138. And I said in one of my speech that by virtue of this legislation, the judicial officers have become a recovery agent. And it's very unfortunate the matters are traveled 138 to Supreme Court. And we as judges in Supreme Court interfering in 138 matters. whether it was tried 4 times, from the magistrate to the district judge to the High Court, and High Court to the Supreme Court. So 138, in my view, has to be reviewed by the government and a different mechanism to be introduced. That can be one solution. Mediation with the brother Suryakant has taken up, it's very wonderful. I must congratulate him. But one thing has to be kept in mind. I myself is a trained mediator of 2010. I became a mediator in charge of my state. But my request is mediation and Lok Adalat. There is a very thin line in between. So subjects have to be selected. Which subjects are good for mediation? Which subjects are good for Lok Adalat? An AFCON judgment of this court, where Justice Ravindran is the author of 2010. I don't remember the citation. My request is every person must undergo that AFCON judgment of 2010 of Justice Ravindran. So you understand what are the broad subjects which can be bifurcated for mediation and what are for the Lok Adalat. MACD matters doesn't need mediation, can go to Lok Adalat. Mediation, in my view, in reference to where there are close relations, family relations, neighbors, two partners. They want to share their views, they want to share their agony, but they don't want to make it public. Those matters must go to mediation. Family matters, husband-wife, matrimonial matters must go to mediation, not in Lok Adalat. You want MACD, you want a claim of land acquisition, must go to Lok Adalat. No mediation required. Where public hearing is required, Lok Adalat. Where you need personal relations to be diluted, personal relations to be explored, must be only mediation. That is my view in reference to this. And I'll request to Brother Suryakant from this platform, request all subordinate district judges of the district court, from magistrate to the district judge, must undergo mediation training. Because as on today, I'm sorry to say, people who come here give a faith in the judicial officers to get the mediation. Lawyers are considered, but the majority of lawyers, percentage of lawyers, mediators are not that as that of magistrates. So all judicial officers must undergo training of 40 hours under the directions of this court. I support Mr. Jain, who said in High Court there is a system. One FIR, all matters are clubbed and listed before one bench. It is not in Supreme Court. This view of Mr. Jain must be accepted immediately, and so that at least no hunting of benches may go on in reference to one FIR to different issues going to different courts. That is one thing which can be taken care of. And I'll just give you one. All policy matters in the Supreme Court which go downwards must be by one constituted administrative committee. This court is a Chief Justice centric court. My request is there should be an administrative committee, broad-based senior judges of the Supreme Court who are in collegium. All successive judges who are going to be Chief Justice must be members of the collegium. Bar Association must be member of collegium, and 2 members to be nominated by the Chief Justice. And that administrative committee must work for minimum period of time. Those persons who are nominated must have a term of 2 or 3 years, so that whatever the decisions are being taken by this committee must undergo for another 5 years, 7 years. Otherwise, what we are happening, one Chief Justice take one view, the other Chief Justice turn over. The other Chief Justice take a view, the other Chief Justice turn over. That is not the system to work.
Right.
We have to work in tandem to each other. And the collegiality will come when system will work for 10 years down the line. Policy decisions. So there should be a policy committee to be constituted. Policy matters must be taken by the committee. So everyone follow. Not the Chief Justice alone do it alone. Collective, we must be a collective voice, not individual voice. Collective voice have a right of say. Individual voice doesn't have a right of say. So that is my request to this thing. And I must agree, copy of the bail application in Supreme Court must be served before filing, so that on the first date of hearing, the court will decide whether bail is to be granted, not to be granted. I fail to understand in this court, notice issued in bail application 3 months, 4 months, and then reply system. I never come across in bail applications ever time granted by us in High Court for granting of time for reply. Supreme Court has a unique system. In bail applications, times are granted for reply. What kind of a reply is to be filed? 99.9% reply are formal. No judge look into the reply. But unfortunately, this matters going on. And come one thing. First bail application of 138, 438 or 439 or whatever the corresponding changes, anticipatory or post arrest, the first application must be listed before every court, either the district court or the high court or the Supreme Court, within a time bound program, within a time bound schedule. Lawyer mention, not mention, forget about it. We are not working for the lawyer's mentioning. We are working for the litigant. Litigant interest has to be paramount. So these bail applications are coming for the first time of the accused under 438 or 439. It must be listed within some time-bound framework before the courts.
Point.
And there should be no compromise and must be decided within time-bound.
Point well taken.
I have seen in Bihar and UP, people are filing 32 petitions before the Supreme Court for getting their matter listed before the court.
Is that so?
Yes, it's unfortunate.
Absolutely, yes.
I have dealt with so many petitions of 32. Only request is, please request my High Court to get my bail application listed and heard. If this is a situation he has reached, I think I'm extremely sorry, and I take responsibility on my shoulders that I was not able to reform in the system going on, of which I was a part for almost 5 years. So
Thank you.
These are my remarks, and my only request, one thing more. Judicial officer system has to be reformed. I'm sorry, in Malik Majar and earlier, this court has said our appointment shall be made by the High Court in the district courts, magistrates. I'm sorry, we judges are not meant as a selection commission. We are not trained. My request is the judgment must be reviewed and this recruitment business be handed over back to the commission. Let the state commission make recruitment. High Court may have a right of say. Committee must be headed by the High Court judge. But commission must undertake the selection process, not the High Courts. I share my experience as a judge at the High Court and the examination charge. Lot of time is being spent, and still I remain under this fear that if some leakage has taken place, some paper is out, something wrong happened, everything is come on my shoulders. Whether you are asking me to do my judicial work or I am doing this business of making selection. So my request is, let that judgment be reviewed. Commission be restored back to the selection process of holding selection for the judicial officers, and High Court may have a right of say. Committee be headed by High Court. That's all, nothing more. And in ADJ, only one thing. In ADJ, where we are making selection from limited direct recruitment of lower judicial officers to the ADJ, it must be abolished. Completely banned. There is an infight going on between the judicial officers. So limited direct recruitment must be completely abolished. And ADJ from lawyers. You will find in all states vacancies of lawyers quota in the additional district judge are lying vacant for years and years together. I as a senior judge in my state, I try to make out that 50% of vacancies be transferred to promotion quota. There was a hue and cry by the lawyers. My request is, by a judicial verdict, we can do it. For ADJ lawyers quota, if in 3 consecutive selection years, lawyers are not available, 50% of the vacancy be transferred to promotion quota. What is it? Tarun, let the feedback be taken. In every state, additional district judge vacancies, lawyers quota is vacant almost 50, 55 plus. And they are not being filled for the last 5 years. And no High Court has taken a call, a courage, I may say, to convert those vacancies to promotion quota, make it available to the promotees because of lawyers' persuasion. My request is, by a judicial pronouncement, it can be done. Ultimately, we have to reform the system. I am not against any lawyer otherwise. If you are not able to get lawyers from the best talent for good reasons for the 3-4 consecutive years, how long will you keep the vacancy vacant? One day or the other, you have to take a call, convert the vacancies to promotion quota. So these are my suggestions. Let Brother Suryakant may take a call on whatever he considers to be appropriate. And my good wishes to Suryakant. He has a long tenure. My good wishes, he will do something good for the nation, good for the judiciary, and good for the overall litigant who is aspiring to see that their matters are being decided at the earliest under the tenure of Suryakant. So my good wishes to him once again.
Thank you for so passionately speaking on this. I think Priya Hingorani had to say something. Would you want to say something before we close? Because I thought, no, nothing. No, okay. I thought you wanted to. I would like to thank.
Sanjay was smiling. Sanjay wants to say something. Sanjay, you want to say?
I was just saying that whomsoever you make as judges, try to make more women judges.
That's correct. I agree.
Yes,
there should be a gender equality.
That.
And
I think.
I tell you.
I think I had some premonition that
when I was asked to form a committee for this crew stampede, I was in the one. I take one female officer, and I find out from the selection process for the IPS officers that one female officer is there. And I made him a member of my committee, and I tell you, Tarun, she's a wonderful officer. I'm so impressed. She has a very long vision and a ground reality she understands. And the way she has given me a whole picture, I'm very thankful. Very thankful.
I would just add to that by saying that I think it's very important on the way the selection of the judges is done, whether at the subordinate judiciary or at the High Court or at the Supreme Court. I think time has come where the message of integrity, quality, ethics must be paramount to anything else. That's what I personally, and I think the bar echoes that.
All endorse it. All endorse it.
Yes,
I would like to.
And it's going to happen. I feel it's going to happen.
On this note, I'd like to thank Justice Ajay Rastogi, who's a leading arbitrator based at Delhi and Jaipur, both cities. I have with me Senior Advocate Sanjay Jain, who practices at the Supreme Court of India. I have with me Senior Advocate Priya Hingorani, practicing at the Supreme Court. Appreciate your joining us on this series titled Justice Suryakant as Chief Justice of India, Opportunities and Suggestions. You all very passionately spoke on the subject and added invaluable suggestions, which will go a long way in helping the judicial process and the litigant. Appreciate your joining us.
Thank you, Tarun.
Thank you very much.
Thank you.
I'm so thankful, Tarun, to give this opportunity to us.
Thank you.
Thank you.
Thank you. Thank you.
Thank you very much.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.